Hello, and thank you for joining this program today. My name is David Gabor. I'm a partner with the Wagner Law Group, and my area of practice is HR consulting and employment litigation. This program, 10 Steps Employers Should Follow When Faced with Requests for Leave or Accommodation, was something that I wanted to talk about with you because there's so many problems I've seen my clients deal with regarding the different laws that involve requests for leave or accommodation and mistakes made by other companies. And as Walt Disney used to say, I also want to plus it. That means let's talk strategic. I know one of the challenges that a lot of people in HR have is to come up with strategic plans on a going forward basis. So Sam has been working for Pattern Corp for 2 years. He tells his boss that he needs to take 3 or 4 weeks off because his mom is going to have some surgery. And the question was, what are Sam's rights and what should Pattern Corp do in that situation? Well, in the case I drew this example from, the employer correctly analyzed the rights under the Family Medical Leave Act and concluded Sam was not eligible for family medical leave. Why? Because he had only been with the company, he had been with the company for 2 years, but he had only worked in the last 12 months for 1,100 hours. And as a result, Pattern correctly denied the request under the Family Medical Leave Act, but unfortunately, they did not consider what rights Sam had under state law. And as a result, in this situation, they breached Sam's rights under state law. So we're going to talk a bit about the Family Medical Leave Act and the Americans with Disabilities Act. Those are the 2 federal statutes that probably every one of you is already aware of. But we're going to also make it clear to you that it's important to approach a request for leave, an accommodation, an apparent need that an employee has for leave or an accommodation under state laws and under local laws as well as under the federal statutes. We're going to also touch on a growing phenomenon that is paid family medical leave, which more and more states and jurisdictions are beginning to work with. I mentioned disparate treatment up front because one of the biggest problems employers have is if they don't treat the same type of request the same way each time. Invariably, if someone finds out that they were denied a request, someone else was granted that request, they're going to think it's unfair, whether or not that gives rise to a claim for discrimination. So during the program, we talk about the rights that are created under the federal law. We look at rights created by state laws. We look at the Paid Family Medical Leave Act. And then the last part of the program today is, no, not David Letterman's top 10 list, but David Gabor's top 10 list. And that top 10 list is going to be some takeaways that I hope are valuable for you. So before we get into talking about the Americans with Disabilities Act, grab your writing stick. What the heck's a writing stick? Well, if you want to take some notes, I hope to come up with some things that you can take back to your teams that will help you on a going forward basis. So the ADEA, which was amended a few years ago to broaden some of the rights and protections employees have in response to several Supreme Court decisions that seem to limit employees' rights under the Act. Basically, we break it down into 3 areas. A person who is disabled, a person who's got a history of disability, and a person who's regarded as disabled. So who is disabled? That's a person who's got a physical or a mental condition which substantially limits a major life activity. The illustrations in the statute, in the EEOC postings are walking, talking, seeing, hearing, or learning. And by the way, the Equal Employment Opportunity Commission has got some really helpful information on its website, and if you do want, I would be happy to forward that information over to you. You can feel free to reach out to me. But these are the major activities that have to be impacted by the disability. A history of disability, and the best example of that is a person who has cancer, is treated for the cancer. Maybe it's chemotherapy, 3, 4, 5 years later, the person's in remission, well, the fact that they had cancer, they went through surgery for cancer, would be a history of having the disability. And the third example is regarded as. A person is regarded as disabled if they've got a physical or mental impairment that's not transitory, for example, lasting less than 6 months, or minor, such as, let's say, a broken leg, and the leg will heal in 6 or 7 weeks. And then a person can be regarded as disabled and be entitled to protection. So the ADEA covers companies with 15 or more employees. Also, for a covered employee, there's no waiting period. It could be as soon as applying for a job. So if an applicant submits a resume, at that point, they are protected under the ADEA and cannot be treated unfairly in the process of being considered, interviewed, being hired, and once hired, they can't be treated unfairly because of their medical condition. Now, the only exception might be something called a BFOQ, a bona fide occupational qualification, where a person really does need to walk or run or jump or do something that they can't do because of their disability, unless, of course, they can do it with an accommodation. And the ADA does cover, in certain situations, requests for leave. It certainly does cover requests for an accommodation. And in that regard, when an employee makes a request for an accommodation, or it's apparent that the person may need an accommodation, the next step would be something called the interactive process. And if you're not familiar with the interactive process, basically that would be meeting with the employee and the employer to talk about whether or not we can come up with a reasonable accommodation so the person can perform the essential functions of the job. As an employer, you have a right to ask for certification in the form of a letter or an email from the healthcare professional working with the employee, demonstrating that with this accommodation, this employee is able to work and perform the essential functions of the job. You may go back and forth 1 time, 2 times, or 10 times, but basically, by and large, what you're trying to do is find a way to get this person back to work. And please, 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 remember the D word, document the process. I was in court a few months ago, and the case ahead of me was a case involving a major hotel chain that said we went into the interactive process and we were not able to come up with something because the employee was unreasonable. Well, show me your record from the meeting. And the lawyer said, well, you know what, we didn't document the process, but we did go through it. The judge says, if you didn't document this, as far as I'm concerned, you never went through it. Adverse employment action. This is really important. If an employee makes a request for an accommodation or for leave, and within a relatively short period of time, something bad happens. The employee is dinged, demoted, fired, suspended, transferred. The employee may say that, but for my request for leave or for an accommodation, I would not have suffered that adverse employment action, and the employee may very well have a viable claim in that situation. Now, let's talk about the Family Medical Leave Act. The employer needs to have 50 or more employees within a 75-mile radius of the work site where an individual seeking leave works. The individual needs to have been working for the company for no less than 12 months. And in the 12 months prior to leave, the individual was working full-time. The definition under the FMLA is 1,250 or more hours. So the individual can take up to 12 weeks over any 12-month period for the individual's own serious health condition or because of a need to care for parent, spouse, or child with a serious health condition. The employer has a right to ask for verification. to confirm, yes, this individual does have a serious condition, or the individual's immediate family member, parent, spouse, child, has a serious health condition. And, and if the employer wants, they could have the employee go to their own doctor in addition to the employee's healthcare professional, but if they do that, the employer has got to pay for it. Leave can be taken at one time, or it can be taken intermittently in blocks of, for example, 4 hours. And very important, when the employee comes back to work, the employee comes back in the same or comparable position. And there is no obligation for the employer to pay for family medical leave, but the employer must follow its regular pay practices for people who are on leave. I mentioned before state law, and the state law that covers is the state where the employee is working. If it's a local law, it's the locality where the employee is working. So when you are faced with a question of leave, of an accommodation, every state's different, but every state has its own definition of disability. Some local areas, for example, in New York City, have their own definitions of what is a disability. And a running joke in New York City is pretty much everything is deemed a disability. Some examples of state leave laws would be, in addition to just regular rights under their disability statutes, PTO, personal time off programs. And in some states, employees accrue a certain amount of leave based on the hours that they work. Some states have something called the Small Necessities Act, and the Small Necessities Law allows them to take some time off for certain situations. Some states have a domestic violence protection where an employee who is the victim or an immediate family member is a victim of domestic violence could take time off to deal with that situation. They have maternity leave, paternity leave, rights with respect to voting or jury duty. And there are times where the protection under the state is very different from what's protected under the ADEA or FMLA. And in that situation, it's your responsibility to provide the benefit that's the greatest benefit to the employee in that situation. Now let's talk about the paid family medical leave. And the paid family medical leave is a relatively new phenomenon over the last few years. And at the moment, Washington, D.C., California, Connecticut, Massachusetts, New Jersey, New York, Oregon, and Rhode Island have programs or are working on programs for PFML. And basically, the way these programs work is an employee has a right to take leave for their own serious condition, medical leave, or for a family member, and each state has its own definition of what is a family member who has a serious condition, family. They're paid unless the employer opts to do it by opting out of a state program. They're not paid by the employer, they're paid by the state, but the employer and the employee are making contributions on a regular basis to a state fund that manages the program. And for example, some states might say, let's say if you're making $75,000 a year, you might get $600 a week for up to 12 weeks or some amount of time to be out on leave. And they also talk about the fact that when you are finished with your leave, you have a right to return to the same or a comparable position. And one of the things you should be very much aware of is how that state treats leave under the PFML and family medical leave. Do they run concurrently or not? Because tracking that leave is very important to the employer. Now, let's jump forward and get to the top 10 list. And the first one is your employee manual. On a regular basis, I review manuals for companies that I work with, and I do find oftentimes that the manuals are not keeping up with the laws in all the different states where they've got employees working, or sometimes even under federal law. So it's very important to make sure that you do update your manuals and check your manuals really at least once a year. You should get a ping from Employment Law Council telling you there's been a change in a law in a state or a jurisdiction where you've got employees, and then make the appropriate adjustments to your employee manual. And here's one of those times where you want to think strategically. So for example, if you've got one state that has a right or benefit for employees of X, and in another state it's X plus 4. And in the first state, you're only giving X, in the second state, you're giving that greater benefit to the employee. The employees talk to each other, and if an employee in the first state finds out that other employees are getting a better benefit, they really do not care at all whether or not the difference in the benefit is because of a difference in the law. What they care about is what their benefit is. And you may run the risk of having dissension, morale, employee engagement issues, and one of the charges that employers have right now is employee retention. So to the extent it's possible and a good business decision, you may want to have employees throughout the company receive the same benefits. And then again, it would have to be something that is at least as good as the benefits available in all the different states or jurisdictions where you've got employees. And let's talk about dissemination. You've invested in and you've created a wonderful benefits program for your employees, and you're proud of that program. Not every employer does a very good job of letting the employees know about what program the benefits are available. And it's a constant effort on your part to be sure that you distribute and disseminate the policies. And oh, by the way, it's also a really good opportunity as an employer to be in front of your employees and talk about this program that you have got for your employees that you're proud of. And you offer this program because you want this to be viewed by your employees as a great place to work. It's a chance to reinforce your mission, your values, your core values, your culture, and the kind of company you want to be. You can also consider, when you disseminate and you broadcast this, you can consider this being part of other training that you're doing during the year, like your harassment prevention training, management training, and if you are a company that does diversity and sensitivity or diversity and inclusion training, part of that program, reinforcing what you want this place to be. The third one, and the reason why I talk about the advice that you need to give to people on leave is because the Equal Employment Opportunity Commission has dinged several different companies in massive litigation when the company had a policy that says, you know, you can be out on leave up to 6 months or up to 12 months, whatever the policy is. And you're welcome to come back to work when you're able to perform the essential functions of the job. Several major corporations, multinational corporations, had that messaging going out to their employees on leave. And the EEOC said, wrong. No, what you need to do is you need to advise the employees that they can come back if they are able to perform the essential functions of the job with or without a reasonable accommodation, thereby inviting the employee on leave to request or enter into the interactive process and burdening or saddling the employer with the responsibility of entering into the interactive process to see if this employee can come back to work with a reasonable accommodation. The fourth one, preparing managers. And the reason why I talk about this one is because there are several cases I've monitored and cases I've been involved with where the managers were ill-equipped to handle requests for leave or accommodation. The first one, which was not one of my cases, involved Dollar General. Dollar General had a diabetic who was working on the floor, and she's type 1, and she's prone to getting low blood sugars called hypoglycemia. So she asked her manager, not once but twice, may I have a sugary substance so that if I get a low blood sugar, I can have that to drink and stabilize my blood sugar. And the manager says, no, you work on the floor, you cannot do that. So the employee has a low blood sugar. She goes into one of the coolers on the store, takes out an orange juice and drinks it, stabilizes her blood sugar, goes to one of the cashiers, pays for the orange juice, retains her receipt. The manager found out that she did this, and the manager, unfortunately for the company, did the really incredibly dumb thing of firing the employee, bringing in somebody from loss prevention. She sues. The case goes up to the Circuit Court of Appeals, and the court found that Dollar General did not give her the reasonable accommodation. The cost that was paid for her and her legal and for her counsel was close to $750,000. They had to pay their own defense costs on top of that. This was an incredibly expensive mistake. So what should have happened is, in this instance, had there been proper training, and for some of you who have endured some of my programs, this is the best way to describe it. Proper training of managers is like being at a red light, busy intersection. You got a lane on your left, you got a lane on your right, there are people walking around the street, lights red, you're the front car. Light turns green, you floor it. No, you don't do that. You look left, you look right, and then you go forward. Now, nobody's training you on that day. David, you're at that red light, look left, look right. It becomes your human nature. You know what you're going to do each and every time. And that's what should be expected of managers. They need to know what to do. If an employee comes to them and says something like, I'm a diabetic, this is something I need, the manager should reach out to whomever in HR partners with that manager and mention to the person, this is the request that's made. How do I handle it? How do I respond? And they will get the appropriate coaching in that situation so they know what they're doing. That's what should have happened. It didn't happen. Okay, now the second example I'm going to give you is a situation that occurred, and this was a client of mine a few years ago. And in this situation, there was a person who needed a flex schedule for some medical appointments, and the request was granted. And the manager knew about it. The manager talked with the HR person working with that manager. Everything's fine. The manager goes out unexpectedly for a week, and the employee with the accommodation is assigned to a different manager. That new manager had no knowledge of the accommodation, so the employee comes in late, and the manager writes up the employee for coming in late. You didn't call. You didn't follow our policy. You know, you're on a written final warning for this. The person who that manager consulted with also did not know about the leave. Fortunately, in this situation, this is a very progressive company in other respects, and they had an early resolution program where issues that are brought to HR in certain instances would lead to a form of investigation and mediation, and there was a mediation, and it was resolved without the employee losing a job and without attorneys from the outside coming in. So those are two examples where managers really need to know in advance what's going on. The fifth point is consistent application of policies. And you heard me mention before the word disparate. If there's disparate treatment of two people in similar situations, you run the risk of litigation and employee morale taking a hit. So what happens is, if you're able to centralize decisions regarding leave, regarding a request for an accommodation, so that you are consistent in what you're doing, you're reducing the risk of running into any kind of trouble in this situation. So what I urge you to do is make sure the process is centralized. Make sure that the people who decide whether or not to give leave, to give an accommodation. It doesn't have to be the same person, but they need to meet on a regular basis to review what they've done in certain situations so that if there is any form of a request for leave, for an accommodation, you don't run into a situation where, for example, one person who's a 60-year-old is denied an accommodation, a 40-year-old is given the accommodation, and they're almost identical in what the requests are. Why? Because a 60-year-old is going to cry age. If it's a male and a female, they might cry gender. They might cry religion or race, because almost everybody can arguably say, I'm in a protected class. So you don't want to expose yourself to having an unhappy employee going to an outside attorney, usually the firm of Dewey, Cheatham, and Howe, and having them bring a complaint against you or filing with an administrative agency. So let's jump up to number 6. And this is where how we approach requests for leave. If a request is made by an employee, remember, it's the jurisdiction where the employee is working. You should have in front of you what protection is available to employees working in that jurisdiction. And you've got a précis on ADEA, FMLA, the state disability law, all the other unique laws, rules, or regulations that govern employees in that jurisdiction. And you have them in front of you. And then you check off the boxes to see which provides the employee the greatest amount of relief, and that's what the employee would be entitled to. Where I've seen mistakes have been typically where someone doesn't have that list in front of them, and they're not aware of it. And oh, by the way, for those of you who work in different industries, whether you're in finance, banking, hotels, you're an inventor, you create apps, whatever you do, or people in your company do, they're brilliant at that. And that's way beyond my knowledge. But I know my areas of law, and it's very important that you know these areas, because what a court will say if you don't follow it is ignorance of the law is no excuse. The 7th point is the interactive process and record keeping. The interactive process, again, is sitting down with the employee, going back and forth with the employee, seeing whether or not you can come up with a reasonable accommodation to allow the employee to perform the essential functions of the job. And you have a right to get something from the doctor indicating that the employee can do the job with the accommodation, and you have the obligation to make a record of the interactive process, what day it took place, where it took place, what time it started, what time it ended, who was present during the interactive process, what was the first request, what was the response, was there a counter, what was the response. Document the whole process and put it in a safe place in case you need it. The 8th one is tracking time off and documentation. And this is something that you really need to do by law. It's critical that you do it. You make sure you are keeping track of whether they're taking intervals of 4 hours or 2 hours or full days, how much time they're taking off. And when the time is exhausted, make sure that the company takes whatever are the appropriate steps at that point in time. If you're not tracking the time off, you may run into problems regarding pay practices, other issues. You may run into insurance problems, LTD issues, STD issues. There are so many different things you can avoid by making sure you track the time they're off. And who owns it? Take a moment and think. Who owns David Gabor, who's working in such and such a department, taking time off? Who owns keeping track of that? And again, you're documenting the process, Number 9, pregnant workers. Now, all right, what's wrong with Gabor? They don't get a reasonable accommodation. It's not a disability. No, I'm not suggesting pregnancy is a disability. What I'm suggesting is approach an employee who's pregnant who may need an accommodation to continue to work as if you are looking at it from the interactive process. get a letter from her healthcare practitioner saying, with this accommodation, she could perform the essential functions of the job and engage in the interactive process. You're doing this both for a compliance standpoint, but also employee engagement. Chances are, if you've got a person who's, let's say, 6 weeks into a pregnancy, she's going to be there for a couple more months. She's having a problem, whatever it is. You want that employee to go through the interactive process to keep that employee working. There's a good chance that a lot of people in the company are excited for her and want her to continue to work during the balance of her pregnancy. So it's really important that you do it. And then the last point on the top 10 list is privacy and retaliation. And on this one, it's, in my very humble opinion, a big mistake when managers are not trained to refrain from sharing information given to them by an employee. So let's say, for example, Gabor goes to a manager and says, I need an accommodation because I've got a condition. I've got leukemia. And the manager 1 tells manager 2. And before you know it, all 250 employees of the company know that I've got leukemia. I may have legal rights that have been violated because the manager shared my information with others. I'm certainly going to be incredibly upset with that manager and with the company because my private information has been shared and it was done in a way that should not have taken place. So from that standpoint, privacy is critical. Retaliation. If an employee engages in a protected activity, a complaint of disability discrimination, or a request for leave, a request for an accommodation, and the employer is aware of that, and obviously they are because the request was made to a manager or to leaders of a company. And within a short amount of time, legalese, close temporal proximity, defined as somewhere between 2, 3, 4, and in some states as much as 5 months, something bad happens to the employee. That's a retaliation case. And the employee has laid out a prima facie case. And even if the employee was wrong in the request for an accommodation or for leave or a complaint of discrimination, but reasonably believed the employee was within his or her rights, the employee has a retaliation case. So our time is up, and I thank you all for attending the program today. You can see a link that's on the slide, and that's on the Wagner Law Group website. And later on this week, I think this will be available for people if you want to access it or share it with other people. If you've got questions for me, you want to talk shop, you can reach me. My direct dial is 617-532-8035, and my email is here as well. Thank you very much for attending.